we are on the record in case number 23 CV 345. This is the matter involving Scott Schara et al. And Ascension Health et al. Mr. Schara, you're here in person. Attorney Adam Jarko, you are on the Zoom call. Are you able to hear us and see us?
Yes, Your Honor, I am.
Okay, and you're representing the plaintiffs?
Yes, Your Honor.
And are you representing, I said that plural, just, I know Mr. Schara had submitted a letter, I think prior to your involvement, indicating that he wasn't going to proceed with the estate claim. Then you became involved. So are you representing both the estate, all plaintiffs?
Yes, Your Honor.
Okay, and that's how I understood it when you guys got on board. Is there anybody else on Zoom on your behalf, Attorney Jarko?
No, Your Honor. Attorney Barnhart, who we have submitted the pro-hack motion for, is in the gallery in the courtroom. And we weren't clear on what the procedure of the hearing would be, but we were thinking maybe you would take up the pro-hack first.
Yeah, and you're able to come on up the table if you want. Any objections if he's at council table and argues?
No, Your Honor. No, Your Honor.
Okay. So you probably see him in the screen joining at council table. And then anybody else, Attorney Jarko?
No, Your Honor.
Okay, and then on behalf of the defendants, you want to state your appearances?
On behalf of St. Elizabeth Hospital and the Ascension entities, Jason J. Frankowiak.
Good morning, Your Honor. Attorney Randall Guzzi appears on behalf of Dr. Gavin Schara in Fox Valley.
Okay, we're set today for the motion that was filed, and I think everything has been briefed. Is there any interest in making an argument? I'm prepared to make a decision, but since everybody's here, do you have a preference? I don't know who's taking the lead for the plaintiff.
Your Honor, Andrew Barnhart for the plaintiff. We're prepared to rest on the pleadings. We don't need to make an oral argument today.
Okay. Thank you, Mr. Barnhart. Mr. Frankowiak.
Your Honor, I believe the issues have been adequately briefed. In short, we believe that this is a inappropriate motion for a new trial, and all deadlines have passed, Your Honor. So we would rely on the briefing as well.
All right, thank you.
Your Honor, on behalf of Dr. Schara, I would stand on our brief.
All right, well, I've had an opportunity to review the briefs, and I have a decision here prepared that I will read into the record. To the extent that I don't cover something, I would think that the record in its entirety will explain better what actually happened, you know, with details with the trial. But with respect to why we're here today, the plaintiffs have moved to set aside the jury's verdict in favor of the defendants. Mr. Schara, and now through counsel, but originally when he had filed the motion, he was pro se, alleges that this court was biased against him or the estate, and that I denied his motions in limine, seeking to exclude evidence of his religious beliefs and motivations based upon or because Mr. Schara had given an interview to the Appleton Post-Crescent, a publication that had been critical to the court in the past. Before addressing the specifics, I want to set forth the legal standard. A party may move to set aside a verdict and for a new trial based on errors in the trial or because of newly discovered evidence or interest of justice. That's Wisconsin statute section 805.15 sub 1. 805.16 sub 1 indicates that motions after verdict shall be filed and served within 20 days after the verdict is rendered. To pursue a motion for a new trial after the 20-day deadline has passed, The motion must be based on newly discovered evidence and must be made at any time within 1 year after the verdict. That is from 805.16 sub 4. Wisconsin statute section 805.15 sub 3 indicates that a court, if it's within that 1 year time frame and it's based on newly discovered evidence, a new trial shall be ordered on grounds of newly discovered evidence if the court finds, and then there's A, B, C, and D. And I won't read those into the record, but that's the legal framework that I am starting my analysis from with respect to the current motion. A motion for reconsideration may be made with a motion for a new trial. A motion for reconsideration is contingent upon the moving party either presenting newly discovered evidence or proving that there's a manifest error of law or fact. A manifest error requires a heightened showing of wholesale disregard, misapplication, or failure to recognize controlling precedent. A motion for reconsideration cannot be employed as a vehicle to introduce new evidence that could have been added during the pendency of the motion. And then those just last few sentences is my understanding of the statutory law and the case law as it relates to this issue. Mr. Schara acknowledges that he faces a procedural hurdle in that the time for motions after a verdict and to appeal the jury's verdict has passed. Therefore, to obtain the relief he seeks, he must present newly discovered evidence that satisfies the requirements of section 805.15 sub 3. Mr. Schara points out the fact that the Appleton Post-Crescent printed an article critical of the court over a year prior to the start of this trial and argues that the court's bad experience with the Post-Crescent gave the court a biased reason to deny Mr. Schara's motion in limine. Beginning with the first requirement of Wisconsin statute section 805.15 sub 3, namely that the evidence came to the moving party's notice after trial, Mr. Schara argues that if he had known about the critical article sooner, he could have raised the bias issue sooner. Mr. Schara's claim to have only just discovered the potential bias issue is refuted by the record in this very case. When the court discovered that Mr. Schara and or one or more of his attorneys had given an interview to the Post-Crescent on the eve of trial, the court placed on the record its concerns about the potential for prejudicial pretrial publicity, including the court's own past experience with that publication. At the pretrial conference, the court noted the following, begin quote, "I would think what I will tell you, being a judge here for 20 years and understanding the Post-Crescent and not having a lot of faith in their neutral, fair publication of issues, I will predict that it's going to be the Sunday before trial. It will be the front page, and there is a reason that it's not today, right? Because it could be today and we'd have 12 days to deal with it if people forget about it, but it will be the day before trial, or it might be that Monday morning or both. And you know, they don't care about the issues that it will create for us. They are selling papers," end of quote. I think it's important just to note from that quote, and we'll get into this in a few minutes as well, that the court had indicated that that interview would create issues for us, this court, dealing with this trial. And that goes back to the concern to be able to select a fair and impartial jury that was not prejudiced by pretrial publicity, which was the whole focus of that conversation that day. Second, the court had specifically indicated at that time that I did not have a lot of faith in the neutral, fair publication of issues. Mr. Schara was here. Mr. Schara obviously heard me say that. His counsel heard me say that, and they were aware that my opinion, whatever relevance that it has, is that I did not have a lot of trust in the faith or in the neutral, fair reporting by that publication. Thus, Mr. Schara and his attorneys had immediate notice of what he now claims is newly discovered evidence of bias. The defendants also argue that it's highly unlikely that Mr. Schara's attorneys would not have been aware of the article prior to trial. I agree with that. Diligent attorneys preparing for a big case would research anyone involved to ensure a smooth trial procedure. Indeed, in the affidavit, Mr. Schara stated that his attorneys did not share the article with him. Mr. Schara's choice of words suggests that his attorneys did not know about the article. As a represented party, anything his attorney knew is attributed to the client. The article is also neither material nor likely to change the result. The post-crescent article about this court was not relevant to any issue to be decided in Mr. Schara's case, and bringing it to the court's attention before trial would not have changed the result. The post-crescent article is not newly discovered evidence, and it's also not proof of bias. I take accusations that Mr. Schara you've made for the first time after trial about bias seriously. I think it questions the integrity and the way that this trial was handled. You sat through here for weeks, and I think it's offensive and maybe disingenuous of you to suggest that there was bias in the way that this, and I'm not going to burden everybody by listening to all the rulings that went in your favor throughout the trial. Those rulings that went in your favor went all the way up to the drafting of the verdict, where I didn't include a battery claim. I included specific questions, giving you many opportunities to win, despite the defendant's adamant arguments that that's not the way jury instruction should be drafted. And I expect you neither appreciate or understand the significance of those decisions. And I'm not sure how they relate to I had bias against you at all, because that bias would have carried over throughout the trial. I also want to indicate that as the Court of Appeals or whoever you appeal this to next will have an opportunity to read the transcript, the days of testimony and the hours of testimony. And it's pretty clear that there were sidebars that were ruled in your favor. There were sidebars that were ruled in opposition to your position. Those were debated and argued throughout the trial. And whether you won some or didn't win some, they can look at how it was that what was going on. I would also like to point out, Mr. Schara, that I allowed you to give long, really unresponsive answers to a lot of questions. And defense counsel, you objected to that throughout the trial. And I think I tried to stay firm that I was going to let Mr. Schara and his witnesses tell their story. And I allowed that. And a lot of that went into areas, Mr. Schara, that I probably wouldn't have allowed you. I wouldn't have required that you testify to it. And you opened doors on occasions that allowed the defense then to do other things. Again, it's going to burden everybody to have to go back and say on day 3, here's what happened. But there are numerous cases and numerous examples throughout that trial that indicate that. The one other thing that I would like to say is the motions in limine that are at issue with this motion actually then were decided throughout the trial, just like most other motions in limine. So most of the time in trials, you make decisions on motions in limine, like I did in this case. And I told counsel you can renew arguments, you can bring them up because on day 4 of a trial or day 10 of a trial, things may be different. And that happened in this case. And so I think it's a complete misrepresentation by Mr. Schara in suggesting or alleging that those motions in limine were denied in their entirety, because that's just not true with how the trial played out. I think it's disingenuous of Mr. Schara to suggest that there was bias in those motions in limine in light of how they ended up being turned out in terms of the evidence, as well as all other decisions that this court made. And with that being said, I want to just go back to sort of the motion and the lack of any merit in the argument. Mr. Schara points out that to the fact that the court denied motions in limine filed on behalf of the plaintiffs, at that same pretrial conference. And he suggests that the court did that because the court had discovered Mr. Schara had given a post-Crescent interview. That is simply false. What Mr. Schara does not point to, however, are any references in the transcripts at the pretrial conference or at any other time where the court expressed any bias against him or his religious beliefs. Mr. Schara simply states the conclusion that links his interview with the denial of the motions in limine. Beyond the naked statement linking the Post-Crescent article with an adverse evidentiary ruling, Mr. Schara provides no explanation for how that article impacted his case. The court's concern with the interview that's at issue was not that it was granted to the Post-Crescent, because in fact, the disclosure that counsel made was that it was a reporter from the Milwaukee Journal or the Milwaukee Journal Sentinel, and maybe also somebody else from the Post-Crescent. That's the reality of how it was disclosed. But again, Mr. Schara doesn't reference that at all in his motion. The issue or the concern was that it was granted to any media outlet on the eve of trial. Pre-trial publicity was a concern in this case, as it is in most cases, and picking a fair and impartial jury was critical to making sure that this trial would happen. The theory of our trial system is that the conclusions to be reached in a case will be induced only by evidence and argument in open court and not by any outside influence, whether a private talk or public print. Additionally, if the defendants could have shown sufficient risk of prejudice, they would have been entitled to a change of venue. And there are a lot of other legal consequences to that. When the court expressed its frustration at that pretrial conference, it was because the plaintiff's attorneys were experienced attorneys who should have foreseen the likelihood that pretrial publicity could taint the jury pool. The court's specific words were, begin quote, "And the point I want to make is the impact it's going to have on the jury in the next 2 weeks that we're going to have to bring in and pick. If there's an article the Sunday before, which I'm hoping you guys were smart enough not to do," end of quote. That's on page 73, lines 3 through 7 of document 563. I then continued on lines 11 through 20 on page 74 of document 563 with the following, end of quote, or begin quote, "I think it's a little bit crazy to have attorneys and parties meeting with the local media with an idea that something is going to be published when they're selecting a jury in 13 days. I find it a little bit offensive. It's almost interfering with our process of selecting a jury. So let's just pretend that the Sunday before the Monday, there's a front page article on the Post-Crescent that is whatever it is. It's Mr. Schara's case, and he's presented himself and his family's case. And I go, you don't think that's going to impact the jury who is coming in the next day?" End of quote. Again, the reason that I'm picking those quotes is, for several pages, my entire focus was on pretrial publicity and being able to select a jury. It had nothing to do with the Post-Crescent or the media outlet or anything personal to Mr. Schara or Mr. Schara's religious beliefs or anything else other than pretrial publicity. The court then also noted that the interview was just part of the plaintiff's efforts to raise awareness of this case through Mr. Schara's blog, websites, social media, and efforts to have people wear supporting t-shirts to court during the trial. That is in documents 563, pages 124, line 9, all the way through page 128, line 19. In the end, the court took the matter of the interview under advisement, which I think is really important. I indicated, begin quote, "Okay, well, we just created a whole other issue that this is what I try to avoid, but I don't know who wants to run with it. So I'm going to take the media issue under advisement. I think what I've heard now is just more irresponsibility by Mr. Schara, if in fact that conversation took place, and I'm going to reserve any judgment on what that means until maybe the article is published. And we'll see what his quotes are. And if they are neutral, professional, respectful comments that were deferring to a jury, and that's what it's all about, then I will take back my comments that I'm disappointed. If they are everything that I would expect I'm going to read, then I have a real problem with it. So that's my decision on the media issue," end of quote. And that's document 563, page 80, line 16 through page 81, line 3. To the extent that the court addressed possible ramifications from giving the interview, which is what Mr. Schara suggested, that there was a ramification with his motions in limine based upon that interview. The court directed its remarks to the attorney who participated in the interview. And I said on document 563, page 83, line 17 to page 84, line 7, and then page 87, line 24 through page 88, line 7. Begin quote, and it's going to be a no nonsense approach, sort of like what I'm taking right now with Mr. Mendenhall. I'm wondering if he stays on the case. So he's here pro hac vice. He did something I wouldn't expect counsel to do. I don't want to overreact, but why should he continue to sit at counsel table when he's doing things that I think are below the standard of professionalism and us trying to administer a fair trial? I just made a note, Mr. Mendenhall, on that. I'm not making any decisions. I try not to make decisions professionally, but I don't want somebody coming from Ohio to disrupt a trial. That's not why I signed off on you being able to be here, but that's the one issue. So like a no-nonsense approach, Mr. Mendenhall may get a letter from me tomorrow saying you are no longer welcome to be part of this case. The difference in this case is not jury misconduct, or if we give them an admonishment on day 3 of the trial and they go do something they shouldn't have done. In this situation, it's counsel and parties doing this, at least from what I've heard from Mr. Boylan and Mr. Mendenhall. And so far, the jurors haven't done anything, but they will do something on that Sunday as a result of conduct by Mr. Mendenhall and maybe other counsel and Mr. Schara. So those, end of quote, those are the quotes where I directed it at Mr. Mendenhall. And again, it had nothing to do with any other decisions or evidentiary decisions that I was going to make that day or at any other day in the trial. It was focused on pretrial publicity and taking into account what would be published or what wouldn't be published, deferring or holding off making decisions until the publication actually happened, and then letting everybody know what the consequences could be. Further, when the court mentioned consequences, the court was warning Mr. Schara and his counsel against further pretrial publicity. So on page 88, lines 16 through 22, I then said, begin quote, so what is Mr. Schara going to do on day 2 of the trial? Is he going to do another interview? Or what is Mr. Mendenhall going to do? I think what I'm about to do when that is published will take care of those issues, but I'm going to wait to see what that is. You are right, but there will be a consequence, and all that consequence is going to be on plaintiff's side, end of quote. Again, that quote is pretty clear that my focus was on pretrial publicity, the impact it would have on the jury, and I was trying to set a tone that I wasn't making a decision that day or taking any consequence that day, unlike what Mr. Schara alleges that I then handed out a consequence by denying all the motions and limine. But I was taking it under advisement, but I was also trying to provide a message, not only to plaintiff and plaintiff's counsel, but all counsel, that we weren't going to do publicity. And I think the record is full of, I had issues on jury safety. And I think you know this, Mr. Schara, but for the first time in my life, I just did a homicide trial last week. But for the first time in my life, I had a jury bust in here where we didn't even want them coming through the front doors because of concerns for their safety and concerns that they would be impacted by others. And so we were taking massive steps, unrelated to any newspaper article or anything else, just to make sure that they weren't going to be tainted by hearing something or seeing something or being intimidated by someone. And I think you're aware of that because you're sitting in this courtroom and decisions were made to that degree. Mr. Schara presents a lengthy argument about how the denial of his motions in limine impacted the evidence presented at trial. But he fails completely to present any evidence of that, let alone a preponderance of the evidence demonstrating bias. As the excerpts from the pretrial hearing demonstrate, the court didn't prejudge the issue of pretrial publicity being prejudicial. The court waited to see what would be published and what additional conduct, if any, Mr. Schara or his legal team undertook as trial commenced. When denying the motions in limine, the court provided an explanation for its ruling and noted that the plaintiffs were not precluded from objecting at trial to questions they felt improper. That is specifically on page 150, line 8 to 152, line 23. The court did not rule that all evidence of Mr. Schara views would be admitted. The court simply found that his views were relevant to the extent they impacted his decisions regarding Grace's care. And in that context, questions about Mr. Schara's views would not be unfairly prejudicial. The court also noted that it would make informed rulings after hearing Mr. Schara's direct testimony. I think I mentioned that earlier, but that is on pages 150 and 151 and 152 of that transcript. Yeah. Mr. Schara argues that the trial did not reveal the truth. But there is a difference between not getting the truth and not getting vindication for what one wanted to hear. Mr. Schara has not presented evidence entitling him to a new trial. He has merely taken umbrage with a fair and impartial jury that listened to days and weeks of testimony and evidence, not giving him the verdict that he wanted. I am just wanting to print out the last email that I received from your head of your legal team, Mr. Schara, and it's been filed. It was one of the most recent documents. Days. Document number 922 in the file is an email that attorney Michael Administer sent to the court on June 21st of 2025, which was the Saturday after the verdict came in on that Saturday morning. And what your attorney said, Mr. Schara, was the following: Mark, I wanted to take a moment to reach out personally and thank you for your tireless effort and patience displayed over the last 3 weeks. Words do not convey the deep admiration I have for your demeanor and evidentiary rulings. I have tried many cases in many jurisdictions, and I can honestly say that you are perhaps the finest jurist I have encountered in 38 years of trial practice. Keep up the good work. Sincerely, Mike. So your lead attorney, who witnessed every one of my evidentiary decisions after a stunning loss, sent an email that said, I have deep admiration for your demeanor and evidentiary rulings. He, of course, didn't think that you got screwed or that you were treated unfairly or that there was some bias or prejudice. And then goes on to say, I can honestly say that you are perhaps the finest jurist I've encountered in 38 years of trial practice. And I would imagine that's probably why he didn't sign on to your current motion or any of the other attorneys that were part of your legal team. I'm very sympathetic, Mr. Schara, as I expressed during the trial, to you or for you and for your family. I tried to treat you with respect. I tried to treat your family with respect. I thought I provided you an opportunity to demonstrate your case, to present your case. I did so because I'd like to think I do that with everybody, despite what everybody, the media wants to portray or say. But when you dig into transcripts and you actually read a case, and if you want to read the one that is Post-President publishes about me, I welcome you come down and read the case. And when you read the case, it'll be different than what you read about their publication of it. But I'm not going to concern myself with those side issues. In this case, I thought you were given a fair trial. Your legal team obviously thought you were given a fair trial. And you come up with something like this on the back end. And I feel bad. The court finds that, Mr. Schara, your desire for someone to blame is an entirely understandable and very human emotion. However, 12 jurors, your peers, after hearing all of the evidence that came in and being presented with all of the legal questions, decided against you quickly, clearly, and really without any concern or objection. And now it appears that your issue is to take blame with the court, that I'm now the focus. And that is what it is. But for all of those reasons, your motion for reconsideration is denied. Your motion for a new trial is denied. We're adjourned.